So without any further delay, let's jump into the video. The Trump administration has introduced a sweeping regulatory change that could significantly narrow access to asylum in the United States under a new rule published in the Federal Register. Migrants may now be denied asylum if they are deemed to pose a public health risk. The regulation, which takes effect Wednesday, expands the government's authority to block asylum claims on the basis of communicable disease concerns. What the new rule does at its core, the regulation empowers immigration officials to prevent certain migrants from advancing in the asylum process if they are considered a potential threat to public health. Previously, many applicants were entitled to proceed to a full asylum merits hearing. Under the new framework, officials may screen out cases at an earlier stage, particularly in situations that fall into legal or factual gray areas. Legal experts warned that this shift gives officers broader discretion to close cases before they reach immigration judges. Morgan Bailey, a partner at Mayer Brown and a former senior Department of Homeland Security official, noted that migrants who once would have had their claims fully heard may now be excluded much sooner in the process. So, why does this matter? Well, this rule adds another powerful tool to the administration's broader immigration enforcement strategy, especially at the United States-Mexico border. It also echoes policies that were used during the early months of the COVID pandemic, when the Trump administration relied on Title 42 public health authority to quickly expel migrants, supposedly to limit virus transmission by linking asylum eligibility to public health assessments. The regulation actually blends immigration law with disease control policy, and that, raises concerns among advocates about fairness, transparency, and due process. All right, let's talk about some key provisions you should know. The rule was jointly issued by the Department of Homeland Security and the Department of Justice, and it includes revised guidance on what counts as credible fear. Screening, which is a preliminary evaluation, determines whether an asylum seeker may go ahead and pursue a full claim. Under the regulation, the administration may actually designate specific countries or regions that are experiencing communicable disease outbreaks and then use those designations when deciding asylum and withholding of removal claims. This approach could, in effect, result in narrower interpretations of what constitutes credible fear. Importantly, the rule does not create an automatic asylum ban and does not retroactively affect individuals who have already been granted protection, a rule with a long history. Originally issued in December 2020, the regulation faced repeated delays and revisions. Subsequent amendments by the Department of Homeland Security and the Department of Justice complicated its implementation, prompting the current action, which removes certain technical changes while preserving the core public health provisions. Although the Biden administration postponed the rule's effective date 5 times, it ultimately did not revoke it, leaving the framework intact. Broader immigration context. This development comes amid a series of restrictive immigration measures under the Trump administration, including halts on green card and citizenship applications for immigrants from certain countries, tighter eligibility standards, and reduced refugee admissions. Refugee intake is set to be capped at 7,500 for fiscal year 2026. Since Trump's return to the White House in January, unlawful crossings at the southern border have reportedly dropped to historic lows. So, what happens next? The regulation formally takes effect on December 31st, setting the stage for stricter asylum screenings shaped by public health considerations and signaling a continued hardline approach to immigration policy. New U.S. rule to bar asylum over security. Who are to be affected? The U.S. administration has formally unveiled a new regulation that allows asylum claims to be denied on the basis of public health risks. Although the framework for this rule was originally developed during the COVID-19 pandemic in 2020 under President Donald Trump's first term, its implementation was postponed. The Department of Homeland Security has now confirmed that the revised and finalized 2025 rule will take effect on December 31st, 2025. So, let's talk about the background and evolution of the rule. The original draft was designed in response to the unprecedented global health emergency caused by COVID-19. Over time, though, certain pandemic-specific provisions became outdated. According to DHS, these elements have been removed in the final version. At the same time, the core public health safeguards have been retained, allowing authorities to evaluate whether an individual poses a security risk to the United States during a declared public health emergency. Now, what the final rule allows under the updated regulation is that individuals may be found ineligible for asylum or withholding of removal if they are deemed a danger to national security due to serious public health concerns. This covers scenarios involving future pandemics, disease outbreaks, or cases where an individual has a severe communicable disease and refuses treatment. Importantly, the rule itself is rooted in immigration and asylum law rather than public health law, even in the absence of a pandemic. Let's look at the policy context and government rationale during the COVID-19 pandemic. The Trump administration relied on Title 42 to expel migrants at the border. DHS now emphasizes that this new rule serves a different legal purpose. Officials have stated that the regulation aligns with broader efforts to ensure that individuals who could threaten U.S. security are not granted asylum protections. 21 immigration judges have been fired in San Francisco, with many reportedly let go without any explanation. Immigration advocates, are raising some serious concerns after a sweeping wave of immigration judge terminations across the United States, with San Francisco emerging as one of the hardest hit regions. Reports indicate that more than 100 immigration judges have been dismissed nationwide in recent months, including at least 21 who served the San Francisco Bay Area. These abrupt removals are already reshaping the immigration court system, and honestly, they're threatening to extend case backlogs for months or even multiple years. Judges have been removed without any explanation. Several of the dismissed judges say they were fired without cause or justification. Jeremiah Johnson, a former immigration judge who served for 8 years, described receiving a brief email notifying him of his termination just days before Thanksgiving. There are now questions of judicial independence. Immigration judges are employees of the Department of Justice and are appointed by the Attorney General. However, Johnson emphasized that the law grants them independent decision-making authority. That independence is not just symbolic. It's supposed to protect judges from political pressure and arbitrary termination, he said. There may actually be a strategy behind these firings. Professor Bill Hing, a law and migration studies expert at the University of San Francisco, believes the firings may reflect a broader enforcement strategy. He suggests that reducing the number of judges could increase delays, making immigrants more vulnerable. One theory is that these prolonged delays discourage people from pursuing their cases. Hing explained that extended detention uncertainty and repeated court postponements can pressure individuals to abandon their legal rights altogether. The Justice Department pushes back. In response to criticism, the Department of Justice defended its actions, stating that it is working to restore integrity to the immigration system after what it described as years of lax enforcement under the previous administration. The department maintains that reforms are necessary to correct systemic issues. San Francisco's backlog is set to worsen, with reportedly only 4 immigration judges remaining in San Francisco. Experts fear the local backlog will escalate dramatically. Cases that once took months to resolve may now be delayed for years, leaving families in prolonged legal limbo. A final word from the bench. Despite his dismissal, Johnson says he remains at peace. Confident that he upheld the law, he recalls the final words he spoke to a family seeking asylum in his courtroom. "Welcome to the United States." Now Johnson is calling on Congress to scrutinize the Attorney General's actions and demand a clear plan to ensure undocumented immigrants retain meaningful access to their day in court. The United States is set to hike immigration fees from January as the Trump administration tightens visa and green card rules. Beginning January 1, 2026, the United States will introduce higher fees for select immigration applications following an inflation-linked adjustment announced by United States Citizenship and Immigration Services. The revision applies to specific immigration benefits, governed under H.R. 1, and reflects the inflation measure between July 2024 and July 2025. USCIS has made it clear that applications postmarked on or after the effective date must include the updated fees or risk outright rejection. The Department of Homeland Security has also signaled that these fees will be reviewed and revised annually as mandated by law, while some immigration-related charges will rise. Others will remain unchanged under the current Federal Register notice. Any future adjustments, including potential changes to the immigration parole fee, will be announced separately. Understanding asylum eligibility and status. To qualify for asylum in the United States, individuals must be physically present in the country and demonstrate a credible fear of persecution in their home nation. This fear must be tied to race, religion, nationality, political opinion, or membership in a particular social group. Applicants are required to show either evidence of past persecution or a well-founded fear of future harm. Asylum status itself does not carry an expiration date, and can only be revoked under narrowly defined circumstances by USCIS. Asylees are entitled to several benefits comparable to those available to refugees. Although they are excluded from the Federal Reception and Placement Program, eligible asylees may later apply for lawful permanent residence by filing Form I-485 to adjust their status. Increased scrutiny for green card applicants from 2026 onward. Green card applicants and existing permanent residents from 19 countries flagged as security sensitive will be subject to enhanced screening procedures. USCIS has confirmed that the administration has ordered a comprehensive review of permanent residence approvals involving nationals from these countries, signaling a stricter posture toward long-term immigration benefits, new entry bans, and travel restrictions. A major shift in United States travel policy will also take effect on January 1, 2026. The administration will enforce a full entry ban on citizens from 12 countries including Afghanistan, Iran, Somalia, Sudan, and Yemen. In addition, partial entry restrictions will be imposed on nationals from 7 other countries such as Cuba, Venezuela, and Turkmenistan, limiting the types of visas available to them. Workplace enforcement takes center stage. Immigration enforcement is expected to expand significantly into workplaces during 2026. Authorities plan to increase audits, inspections, and enforcement actions, which could result in higher arrest numbers. Economic analysts caution that replacing workers detained during enforcement operations may raise labor costs, adding pressure to inflation control efforts ahead of critical congressional elections, along with massive funding boosts for border agencies. Under a comprehensive spending package passed earlier this year, Immigration and Customs Enforcement and United States Border Patrol will receive an additional $170 billion in funding through September 2029. This marks a dramatic increase compared to their combined annual budgets of roughly $19 billion, underscoring the administration's long-term commitment to border and interior enforcement, political fallout, and administration response. Public approval of President Trump's immigration approach has declined, with approval ratings falling from 50% earlier in the year to 41% by mid-December. According to Reuters, despite this dip, the administration continues to defend its